Okay, so it is difficult to um, talk about the Sherman Antitrust Act without talking about the Clayton Act. They basically come together as the two biggest pieces of the puzzle in preventing anti-competitive or monopolistic behavior. All right, so the Sherman is the older of the two acts, and the Clayton Act was enacted to fill in some of the gaps of the Sherman Act. Um, And so, as the name indicated, the Antitrust Act was, it enabled the government to bust up trust, required divestiture, which is basically selling off um, interest of the trust when there was control of an entire industry. Well, that it didn't give the federal government the power to break up companies and the approval um, of mergers, proposed mergers. All right, that came from the Clayton Act. All right, let's talk about a few things before we get into specifically what the Clayton Act, um, the real teeth of it. So, price discrimination. All right, um, this is charging different buyers different prices. All right, and that is precluded under the Clayton Act. Um, that's the general rule, but there are several asterisks with that. All right. And so, what it amounts to is if you're going to charge different groups of customers different prices, you have to have some justifiable and legal basis. So, you can't do it on the basis of race or other protected classes, but you can do it on the basis of cost. In other words, if you can prove that it costs more to serve a certain group of consumers, then you can charge those consumers more, right? And this is often the justification for retailers who charge higher prices in lower income neighborhoods, in minority owned neighborhoods, and things of that nature. And the logic is, well, it costs more to serve those consumers. There's more security that's required in those neighborhoods. Maybe the risk of theft and shrinkage is higher in those neighborhoods. And so that really is a justification, legally substantive justification that works in those cases. Meeting competitors' prices. So if there is different competition in different geographic areas or different market segments, and you have higher levels of competition in some markets that you compete in, then that also will serve as a basis for differential pricing or price discrimination. And of course, changing market conditions in for the same reason. All right. So those are defenses to price discrimination, and we know that this exists. The reality is that it can't exist without one of these defenses present. You can't just say, I'm going to charge this group of consumers more because I feel like it. That's price discrimination. Exclusive dealing contracts. Now, we talked a little bit about this in section uh, one, as it were, of the Sherman Antitrust Act, but the Clayton Act expounded upon that a good bit, um, and basically forbid um, exclusive dealing contracts that ultimately harm the consumer. That result, we're talking business to business contracts, and ones that drive prices up for the consumer or reduce the range of available options for the consumer. Those are prohibited under the Clayton Act. Right? And of course, it is illegal but not criminal under the Clayton Act. And actually, let's talk a little bit about what that means, illegal but not criminal, because your text references that but doesn't really explain what that means, illegal but not criminal. So really what that means is that third parties, when they are able to demonstrate a violation of the Clayton Act, um, can sue for damages in court. All right. And there's wherein the illegal but not criminal comes into play. It doesn't necessarily mean that the company can be held criminally liable, all right? But injured consumers or injured third parties can sue for damages under the Clayton Act. All right. So I'll start with tying agreements. This is tying one product to another, and that's really only actionable for commodities, things like oil or energy trading and things of that nature. So if you're buying oil from me, I can't tie it to make you also buy natural gas, right? Um, it doesn't really apply to consumer goods because you've often seen consumer goods tied from, various for various reasons, right? Um, Consumer goods aren't covered under the Clayton Act. Let's talk about interlocking directories. This is actually quite simple. And there is a threshold, I believe it's 34 million. It's indexed, it changes. But subject to certain thresholds, one director cannot serve on the board for a business and its competition. All right, and that's really what that interlocking directories rule means. Is if I'm on the board for General Motors, then I can't be on the board for Ford. Right? If I sit on the board of directors for Royal Dutch Shell Corporation, then I can't sit on the board of directors for Chevron. All right? That's really all that means. So let's talk about mergers, right? And these often are in the news because mergers have to be approved above a certain threshold. Um, and the most recent one that was in the news was after the merger between Sprint and T-Mobile. All right, you may remember that Sprint and T-Mobile's merger was one of a lot of political import, in that the concern was that there are four major providers of cell phone service, right? AT&T, Verizon, Sprint, T-Mobile, and going from four to three may mean that there's less competition, right? And of course, there are your smaller providers, but to be, honest, they all lease access from one of those four providers, right? So even if you're with Cricket or Spectrum Mobile or Visible or you name it, there are a bunch of them, but they all go through these four providers. So for all intents and purposes, there are four providers of cell phone service, and whether your service is branded as one of those four, your business is actually in the portfolio of one of those four, right? And um, that's why the merger between T-Mobile and Sprint achieved such scrutiny. It was approved, right? Sprint and T-Mobile have officially merged, and as a result, there were several promises that T-Mobile had to do and certain things that they had to continue to provide for a stated period of time as kind of an accommodation for its approval. Let's talk about another one, and this one maybe you're aware of, maybe you're not, but it relates to the accounting field, public accounting. And so mergers among firms are in fact very common, right? And so if you've ever heard the firm Big Four accounting firms, at one point in time it was Big Eight, right? And you know that the gap between those Big Four firms is a mile wide. Like the next largest firm is, is the next largest tier is your BDO Seidmans and your Grant Thorntons and your RSM McGradleys, but they are still fractions of the size of the Big Four firms, right? So I referenced a few minutes ago, the Big Eight firms. Well, the Big Eight firms were the largest 8 firms that existed, and they started merging and combining with each other, all right? And they got down to 5. So when I was in college, there were 5, right? And they were KPMG, PricewaterhouseCoopers, Deloitte and Touche, Ernst and Young, and Arthur Andersen. All right, and and so when that merger that took the Big Eight down to 5, and it actually was several mergers, but the last one that went from 6 to 5, the Federal Trade Commission, which has to approve these mergers, basically indicated that that was as concentrated as they were going to approve. Right, 5 is the right number. Any less than that will result in anti-competitive behavior, and so for a while there were 5, right? And obviously, Anderson played fast and loose with Enron and signed off on things that were not, in fact, should not have been, in fact, signed off on. And so Anderson ceased to exist, right? And what effectively happened, and I lived through this, so um, it was a de facto merger or bifurcation, if you will, of Anderson, because even though Arthur Anderson as an accounting firm dissolved, there still was the same amount of accounting work in the world. And if you haven't figured this out about the industry, smaller firms really aren't scaled to do the work of a big accounting firm. So as a result, there was a mass hiring frenzy. All of the other 4 firms expanded somewhat, some more than others. They all hired Anderson's people. The partners got on as senior managers, and in many cases, partners at other firms, and other firms hired Anderson staff. I actually was affected by this as well. I was an Anderson intern who ended up working for Deloitte. All right. And that's created some issues, right? Because with the enhanced auditor independence rules, it's difficult to do the audit and also provide consulting work. Well, the reality is companies need a lot of stuff. They need audit work, they need tax work, they need consulting, and it's made it more complex, to be quite frank. And the reality is that it's not uncommon for large companies to do business with at least 3, or in some cases all 4 of the Big Four firms, just to preserve independence. Okay,